Good morning, everybody. Thank you for joining us, bright-eyed and bushy-tailed on a Monday to talk about foreclosure basics. I am so thrilled to be presenting with my colleague and my friend, Michelle Brix. We are both at CLS. I'm an attorney in our homeownership and consumer rights unit. I came into the foreclosure world back in 2008, actually, when I was working for Judge Rizzo, who helped create our mortgage foreclosure diversion program here in Philadelphia. And from there, I've been immersed in this area of law since and found myself at CLS about a year and a half ago, which I'm thrilled to be there. I met Michelle when I was working for the courts, and she was a housing counselor with the foreclosure diversion program. And so I'm, again, so thrilled that she and I get to work together and are presenting for the first time together on foreclosure basics. And I'll let Michelle introduce herself momentarily or briefly here as well. Go ahead, Michelle.
Good morning, everyone. My name is Michelle Brix. I started in this work thinking that I was going to help seniors find affordable housing and move sort of calmly into apartments and in a senior center. And it happened to be the height of the foreclosure crisis in 2008. And so instead of doing that, I became immersed also in the foreclosure world and learned about all of this as a housing counselor. And I continued this work at the senior center for 5 years in Germantown in Philadelphia. And then I became a paralegal doing similar work with lawyers at Community Legal Services. And I'm excited to give you some of those basics today that I learned as a housing counselor and also transition into a more legal-based understanding of the foreclosure process. So thanks for coming this morning.
Oh, let me... All right, so here's our agenda for today. Like we said, we're just doing some basics of a foreclosure action, sort of nuts and bolts, start to finish on what a case can look like, maybe what to expect, timelines, things like that. We'll go over basic definitions of industry terms. We'll talk about types of mortgages, the timeline, which is a really important piece, and we'll get into that later. Pre-foreclosure notices that are required in Pennsylvania, loss mitigation and home retention options, litigation, which is still an option in these cases like any civil case, and then we'll touch on what the COVID overlay to all of this is at the end, which is basically things are on hold. As Kelly said, if you have questions, please put them in the chat, or quite frankly, unmute yourselves if you can and just shout them out. We're happy to keep this a very fluid discussion, and I know that there are going to be lots of folks on this webinar that have experience doing this type of work as well, and your experience and your stories are really helpful to bring context to a lot of what we're going to be talking about today, so please don't be shy. And again, thank you all for showing up here. I know, like myself, a lot of you are managing kids at home and a lot of other things to tune in today, so we do really value your time here sharing with us. All right, so Michelle, let's get going with some definitions.
Right, some of these things are going to be really basic for you if you are familiar at all with mortgages or real estate, but I figured it was worth going through some of these terms just so you know what we're talking about throughout this presentation. So a deed is just a legal document signed and recorded indicating ownership of property. The mortgage and note get paired together. A mortgage is actually, you're paying back a mortgage, but that is just the instrument that secures the loan. The note itself is a promissory note, and it's referred to as a mortgage note, and it's what you use to indicate how you're going to pay back the loan that is secured by your property, and that's the mortgage. Amortization is where you have a chart. If you have a 30-year mortgage, the amortization chart is how that mortgage is broken down over the course of 30 years, how it gets paid back from principal and interest, because the lender and investor is making money from this loan. So the amortization chart kind of shares over the course of 30 years how much they're going to make in interest and how much you're going to pay back in principal every month with every payment. PITI, or sometimes called PITI, that mortgage payments are made up of a combination of 4 to 5 different parts. You have principal, interest, taxes, and insurance. The insurance piece of this is always homeowners insurance, but sometimes can also include private mortgage insurance, which is called MIP or PMI. The taxes and insurance make up the escrow portion of the payment. That's the annual cost of property taxes and insurance that the lender will pay in advance, and then you pay into that escrow over the course of the year as a borrower. Mortgagor and mortgagee. A mortgagee is a lender or servicer, and a mortgagor is a borrower. I learned the handy tip that mortgagor and borrower have O's, and mortgagee and lenders and servicers have E's. Default and delinquency. Those get used interchangeably often as well, but delinquency means getting behind on payments. But once you're delinquent for a certain period of time, in mortgages, it is 60 to 90 days often, your lender will declare the loan to be in default, and then the entire loan balance will become due at that time. Foreclosure is the action of taking possession of a mortgage property when the mortgagor fails to keep up with their mortgage payments. Judicial versus non-judicial foreclosure. Non-judicial foreclosures happen when a mortgage agreement has a power of sale clause that gives the lender the right to foreclose on a property by itself. Without that clause, the lender has to take the borrower to court in order to foreclose, hence the term judicial foreclosure. We are a judicial foreclosure state in Pennsylvania, and we'll talk about that a little bit more later. Plaintiff defendant. Defendant is usually the one being foreclosed on. The plaintiff is the lender or the one suing in the lawsuit. And finally, we have housing counselors. Housing counseling agencies provide counselors who are certified by HUD or other national organizations to offer financial and budget counseling, guidance for new home buyers, and assistance with hardship applications when a homeowner becomes or may become behind on mortgage payments. Counselors gather requested information like proof of income, hardship information. They'll do a budget expense or a household expense analysis. And sometimes they'll create a proposal for repayment or for new terms for a loan modification. And then they'll submit everything to a lender, and then the lender will review the homeowner's financial circumstances for a resolution that results in an affordable payment moving forward. And counselors are often very adept at helping with those negotiations with the homeowners and the lenders. Often there's terms or ways to describe a problem or a financial situation that a homeowner will just be like, ah, and the housing counselor knows the language to use to communicate with the servicer more effectively. So next we'll talk about what kind of mortgages people have.
Michelle, can I go back and ask you a quick question? Can you talk a little bit about, because I do think it's interesting. So the foreclosure crisis happened initially, because here we are again, in 2008. What was the role of the housing counseling universe before the meltdown? What was the purpose? What was the thought behind housing counselors?
Housing counseling did a lot of pre-purchase counseling and helping people with first-time homebuyer programs. They did credit counseling and did some default counseling, but for the most part, the default delinquency counseling and anti-predatory loan counseling happened on a very kind of case-by-case basis. There were some methods that you could use to negotiate with servicers, but once the foreclosure crisis happened and the HEMAP program was created, it became a lot more standardized and very kind of a universal understanding of how to negotiate for loan modifications. But housing counseling has been around for a long, long time.
That's great.
All right, so now we're going to talk about often if a person gets behind, they will be asked what type of mortgage that they have. And that's really important for anyone who is advocating for them to know. There are usually they get lumped into, do you have a conventional mortgage or an FHA mortgage? But here's how to break those two down. So a conventional mortgage is a non-FHA. Well, let's cover FHA first. So FHA are loans that are insured by the Federal Housing Administration through HUD. They have very specific guidelines to get a loan like that and housing counselors help with those. Those are first-time homebuyer programs come through FHA typically. Conventional mortgages include GSE or government-sponsored entities like Freddie Mac and Fannie Mae. They are large government chartered corporations that own or guarantee over 1/2 of the home mortgages in the country today. Non-GSE mortgages are private investors. Reverse mortgages are HECMs, and we will talk a little bit more about those later, but those are the exact opposite of a forward mortgage that you would use to purchase your house. You have to be 62 or older to get a reverse mortgage, and we'll talk more about that later because you don't make payments on those mortgages, but they do go into foreclosure, and so we'll talk about what to do if you have a reverse mortgage case for a little bit. Federally insured mortgages include not just FHA, but VA loans or rural housing services loans. We do not in Philadelphia deal very much with, we don't deal at all with RHS loans, and we very rarely deal with VA loans, but those are out there and exist. And if you get someone who comes to you with one of those loans, they also have specific guidelines. Then we have home equity loans and lines of credit, HELOCs. Those are typically second mortgages. The mortgages we deal with primarily are purchase money or refinance loans that go into foreclosure, and because they represent often a big balance, those are the ones that go into foreclosure first typically. Home equity lines of credit operate on a little bit of a different set of guidelines for loss mit, for how they're serviced and things like that, and are typically second mortgages. And now we're on the timeline. So one of the things that I always would hear whenever a homeowner would get behind on their mortgage is that they would be completely concerned that they are going to go to work or go to the grocery store or go visit a family friend and over the weekend or somewhere else and come back and their house would be locked up, and because they had missed a couple of mortgage payments. One of my jobs as a housing counselor was always to say, okay, let me explain to you what the foreclosure timeline looks like, at least definitely in Philadelphia and some of the surrounding counties. In a judicial foreclosure state, foreclosure takes a very long time. And so I always pull out this timeline, which you can find there. This is a timeline that was put together by the Urban Affairs Coalition. There was a subcommittee that put this timeline together to put together in a book and a guide. There's a link at the bottom, and we'll send a link out to all of you after this presentation, that has this chart in it. It explains all the pieces of the chart, and then it has lots and lots of information specifically to our surrounding 5-county area, but should be useful for people all around the state. But I just want to look at this with y'all for a minute. So you can see this timeline says I get behind on my mortgage payments after 1 month, and then all the way down 12 months later is when the sheriff gives you a move out time. So this is the absolute minimum timeline for a residential mortgage foreclosure in Philadelphia and Pennsylvania. And if you have different experiences, feel free to put that in the chat. But you can see that it takes a really long time, and I'm gonna kind of go through it and tell you where the delays, longer delays actually happen. So someone gets behind on their mortgage, they get after 33 days, they can get an Act 91 or intent to foreclose notice that they can handle. And Rachel's going to talk about that a little bit more in a minute, but that can take 30 to 60 days before they can move to the next step, which is that the lender will file a complaint in foreclosure and actually start the lawsuit. Once the complaint is filed in Philadelphia, you get a conciliation conference scheduled. A conciliation conference, also known as the foreclosure diversion program that Rachel mentioned earlier, that is a place where it is a court mandated program that housing counselors are certified to come into a courtroom with homeowners and with lender attorneys, where they meet together. They talk about each individual homeowner's financial situation. They submit documentation directly to the lender's lawyers, and they have to kind of try and negotiate some sort of workout before the lender can take a default judgment in the case. These conferences you can have a resolution in the first conference, or they can take a lot longer to gather documentation and to get clarification from a homeowner or get clarification from a lender or talk about a decision. And you can often have to go, I think our average is 4 or 5 conferences over the course of several months. They would happen once a week in Philadelphia on Thursdays in a courtroom in City Hall. And counselors were in the courtroom. There were legal attorneys in the courtroom, and the legal aid attorneys in the courtroom, and advocates, and the lender's lawyers. And that program is still existing, except during COVID time. We're just not sure what it's going to look like. But that was a significant way to slow the process down, help homeowners kind of get their bearings and get some goals in mind, and be able to kind of work out some proposals with the lender in a way that that was not as stressful as calling a warehouse of a servicer and getting every different customer service person you can imagine who doesn't know the conversation you just had yesterday with the other person. Like, this kind of streamlines the whole process and gives you a point of contact through the lender's attorney that hopefully will help move the process along to get you a resolution. If things fall apart, and we're going to pop back, Rachel. If things fall apart during the complaint or during the conciliation conferences, and it looks like things just aren't going to work, we'll talk about steps in a minute about what happens whenever things don't work. But in terms of the timeline, just so people know, if things fall apart, then a 10-day notice has to get sent, and then a default judgment can be taken. After the default judgment is taken, a precipice for the judgment and a writ of execution gets delivered to the sheriff, and the sheriff sells the house at auction, usually about 2 to 3 months after the judgment is taken. Then the wild thing is, even after a sheriff sale is held and the property is sold, the person still doesn't have to leave the house right away. A whole new action has to be started, and that's called an ejectment action, and that's another court process where the new owner, or the bank if they bought the house back, has to actually file a complaint for ejectment in the court system. That can also be answered like in litigation, although it's not extremely effective. It'll buy you a couple of weeks. But then after the judgment is entered in ejectment and a writ gets entered, that's when it gets delivered to the sheriff's office, and then the sheriff has to alert the homeowner of when the lockout is put on the calendar. And that can take months as well. We usually tell people it's about 2 to 3 months, but they can call the sheriff's department and ask where they are on the calendar and be as aware as possible for when the sheriff might be coming to do the lockout, to give them time to save money and make a plan about where they're going to go. So takes a long time. And that's often good for our homeowners to be able to kind of get their lives back together, or at least make a calmer plan.
I would say also the 2 to 3 months to get a sheriff sale is Philadelphia specific. I think if people from around the state want to throw in the chat how quickly a sheriff sale gets scheduled, I do think that's important to pay attention to what's happening in your own county, and how quickly things go to sale once they are permitted to be sold. And the other thing about this timeline is this presumes that there's no answer filed, there's no litigation, as Michelle said. So when you start tacking those pieces into these cases, you can really drag out a foreclosure action and try to reach resolution over a long period of time, which is important to stress to the homeowner that there is a lot of time, more time to be had, and it's not as rushed as people think. But this timeline is wonderful, and tack it up in your offices so you know what to expect when people come in. All right. So then we have the pre-foreclosure notice. We'll sort of back up here. You've seen the whole process start to finish in that timeline. But the first thing that has to happen in Pennsylvania is notice has to go to the borrower that says you missed a payment, you're behind. Here are your options. Here are some steps you can take before we file an actual foreclosure action. And these are important notices, and they come in two different ways. First, most you'll see are Act 6 notices, or a notice of intention to foreclose. We've put an example in here on the PowerPoint, and it has to include very specific information. And failure to include this information can give rise to a defense later on in the foreclosure if you do end up deciding to file an answer. And the idea is to make a very easy read. You wouldn't know that by looking at this example, but the idea is to make it easy for the homeowner to determine exactly how far behind they are, the amount of money owed as of that moment, how to pay that money if they have the ability to reinstate, where to send that money, and any other itemization of the money owed should be included. And this is when one of the loss mitigation options or home retention options that we talk about sometimes is reinstatement. And this is the best time to reinstate because this is the least amount of money that's going to be owed. The farther along you get, the more payments are missed, fees and costs, interest start to add up. But typically if somebody's able to reinstate, it's now. And anecdotally, what we notice is people who are coming into our office for assistance are usually pretty far past this moment, and usually we're seeing people post complaint. But every once in a while, you'll get someone early on who has just received an ACT notice and is coming forward for help and to figure out what their options are. And again, this reinstatement amount is stated in this Act 6 notice and is really important to pay attention to. Early on in the foreclosure, sometimes if somebody has lost a job or just had a small blip in the radar, so to speak, lost a job but has already found something else and moving on, sometimes reinstatement can be a really good option for a homeowner. It just depends. Every homeowner presents in a little bit of a different way. So in addition to Act 6, you may also see what's called an Act 91 notice, and these are Pennsylvania specific notices. And these are specific also to non-FHA loans. So in Pennsylvania, you may see an Act 96 notice coming in to your homeowner. And again, it details you've fallen behind. Here's how you reinstate. Here's what you owe. But the most important piece of an Act 91 is the HEMAP notice that comes with it. Act 91 says you're behind, this is what you owe, but also here is a loan program that you may be eligible for if you contact a specific housing counselor listed on the next pages. And they attach a list of housing counseling agencies and they talk about the HEMAP program, which is really wonderful. Needs to be funded more. We'd like to see better money put towards it, but it's administered by PHFA, which is our state housing finance agency. And that's where the magic of the Act 91 is. But in terms of notice, Act 6 and Act 91 are trying to do the same thing in a lot of ways. Tell you that you're behind and tell you how you can cure the amount. And again, the notices are very, very specific. The lenders have to include very specific things. And the itemized breakdown is really important because again, if you're going to defend the foreclosure or buy more time by defending the foreclosure, you can oftentimes look at the itemization and find some defects there. And we've put the link and the where to find the requirements down below. And again, we'll be sending out this information after the presentation. So HEMAP, like we said, is a loan program. It is not a grant. It's a loan. And the thought was somebody who's lost their job, I think, or lost income and then able to recoup that in a relatively short amount of time, HEMAP is for you. Somebody who's facing loss of income over a really long period of time, HEMAP may not be your best option. And part of it is, you'll see here, it says they must be able to show they have a reasonable prospect of resuming full mortgage payments within the required time frame. It's 24 months or 60,000, whichever comes first. But in light of COVID, it's been extended to 36 months from the date of delinquency. And then the repayment of this loan is determined by your household income. You will have to make minimum payments of $25 a month. It could be more. But again, they're going to look at what's coming into the household at that time. With your Act 91 notice, it's going to give you a list of housing counselors, and you are supposed to be face-to-face with a housing counselor within 33 days. And if you can do that, you can put a pause on the foreclosure. It's really important. You can put a halt to everything early on if your homeowner can meet with a certified housing counselor within that time. And that's great, because then what you can do is you can then work on the HEMAP application, get that submitted, and wait for a response. If you do not do that, you don't forego your right to be approved for HEMAP. It's just that if you apply for HEMAP later on down the line, the foreclosure has already started and it's not going to stop now. You lose the benefit of having the foreclosure stopped in its tracks. But you can still be reviewed and approved in certain instances. So it's really important that homeowners be aware of that and try to take advantage of the HEMAP program. There is what's called continuing assistance beyond the 36 month period. Overall, like I said, the HEMAP approval numbers are not what we want them to be. I think they hover, and somebody, Michelle or anybody in this forum can chat, can pipe up here, but I think we're hovering anywhere between, I want to say 10% and maybe 25% approval rates. At any point when we start to make a lot of noise with PHFA and say, hey, what are you guys doing? The approval rates are really low. We start to see an increase over the next 2 to 3 months, and then they go back down again. We think the program is great and we're always advocating for it because it's a loan program. So the money is going back into the system, so to speak, and it can be a money maker in a way. And so we think the funding for it should reflect that. But it's been an uphill battle since its creation, but it is a really important step for homeowners. So Act 6 versus Act 91 notice. Act 6, again, is a pre-foreclosure notice that goes to anybody with a certain caveat. The base amount of the original amount borrowed has to be less than around $256,000. Act 91 doesn't have that requirement. Act 6 also incorporates FHA. Act 91 does not incorporate FHA. Act 6 says it has to be a residential property. Act 91 says you have to be living there to be eligible for HEMAP and to be eligible for assistance. So there's very slight differences. But again, you're going to see Act 91 notices, it's Pennsylvania specific, which for purposes of this presentation pertains to you all. So you are going to see a lot of Act 91 notices for the non-FHA loans. If it's an FHA loan, you are not eligible for HEMAP assistance. And one other question, did I say FHA loan holders do not get, yep, do not, let me be clear, that's a really good distinction to make. If you have an FHA loan, you still have to get a pre-foreclosure notice. It's just going to come as an Act 6 or what's called a notice of intent to foreclose. Sometimes a homeowner will bring in what looks like a form letter that reads just like a letter, Dear Ms. Gallegos, you've fallen behind, and it says notice of intent to foreclose. That's your clue that this is the pre-foreclosure notice. So those notices are really important and have to go out in Pennsylvania specifically, and again, provides additional delay and additional time for the homeowner to try to work something out before they face a complaint in foreclosure. Okay. So let's talk about loss mitigation and home retention tools. And there's a distinction in these words that I think is important that Michelle raised with me when we were talking about this presentation. And she's right, this is a really important. When we talk about loss mitigation is from the lender side. They're trying to litigate their loss. They're trying to mitigate, I said litigate, I think. They're trying to mitigate what happens to their bottom line. And that's their only concern, let's be honest. Their concern is not about community preservation and preventing homelessness. They're looking at dollars and cents. And so they are mitigating their own losses. We use that term interchangeably, but when we're talking about homeowners and we're talking about a legal aid side or housing counselor side, we are interested in home retention, right? We don't care about the loss to the lender. We want our homeowners to remain in their homes for all the reasons that we do this work, and we believe in community preservation, and we believe in people having stable roof over their head for all those other reasons, right? But loss mitigation, when we talk about it, is you're talking about it from the lender side. And your ability to apply for a loan modification is one example of home retention or one example of a loss mitigation tool. But the loss mitigation that the lender is going to offer your homeowner depends on the type of loan you're going to have. And so the tools are going to be slightly different, and it's very annoying in that regard that the answer is it depends. If you're looking at what's available for your homeowner, it depends on what type of loan you have. Is it Fannie or Freddie? Is it FHA? Is it a non-government sponsored entity or a private investor? All those things affect what your options are going to be. So Fannie and Freddie have similar loss mitigation guidelines, divided between short-term options for temporary problems and long-term options when there's significant overhaul in your financial situation. Your servicer has to review you in a Fannie and Freddie context for specific options in a required order. And so the question becomes, well, what are those options? What's the required order? And I would love to know that as well, but it's sort of behind the scenes and it's very hard to get that information. There's a way to do it later on, but there's nothing I can point you to that says this is exactly how they're going to review your homeowner. FHA loans, those, we talked about those through a HUD context. They have really strict guidelines about how loss mitigation should be handled. And they have to run you through what's called the waterfall. So sometimes you'll hear that term of art about we ran your client through the waterfall, which is essentially mean we start here for home retention. If that doesn't work, we go to the next thing, we go to the next thing. And there's actually a chart that you have access to that we will link to that shows you, if you plug in all the numbers that pertain to your homeowner about mortgage amounts, debts, incomes, that sort of thing, it can tell you what a possible payment should be and what a possible resolution should be. So you have access to that tool. That's really important. And then conventional or non-government sponsored. So these are your private investors. And they dictate how their loss mitigation is handled. They're not obligated to run you through the waterfall. They're not obligated to offer you certain things that Fannie and Freddie loans are obligated to do. And it often seems very, very arbitrary. And we debated whether or not to say that, right? Is it really appropriate to say that these are arbitrary decisions? And the answer is yes, it feels that way and it looks that way a lot of times. And when you call to get more information about what happened, you don't get great responses from these types of lenders. It's very, very difficult. So moving on into our loss mitigation and our home retention, these are the terms and the things that your client may have available to them that Michelle's going to run through now.
So most of the workout options to negotiate, like what you do when you get behind, and what do you do when you call your mortgage company and say, I've missed payments, what should I do? These are coming from the place that you want to keep your home and you want to have an affordable payment on your mortgage, and that for some reason your payment has not become affordable, has not been affordable for you for whatever reason. Again, each of these are kind of dictated by your mortgage company or mortgage servicer and type of mortgage, but here's some common terms. A forbearance is hugely popular right now, especially in light of COVID. COVID forbearances have become sort of the catch-all for people who have lost their jobs and can't pay their mortgages until unemployment kicks in or after they are reemployed once the pandemic lockdown lifts a little bit. So a forbearance means a partial or no payment is made over a certain period of time that you both agree. And then at the end of the forbearance time period, usually how it used to work is the payment would be due in one lump sum. If you were 3 months behind on $1,000 payment, on month 4, you would have to pay $4,000 all at once. You'd miss your three 1,000s and then have to pay it all at once. That wasn't great for a lot of people. And so it didn't really work, and it was not a fantastic option for most folks. But right now, COVID forbearances, and if you have a Fannie or Freddie or an FHA loan, those forbearances, they've dictated that the amount that you miss over the course of however many months, up to 12, that they are going to defer that payment those payments, and just stick them on the back of the loan. And that means that if you had a 30-year loan and you paid 20 years on it, and then you miss four months of payments or whatever, then you have 20 years and 4 months left on your loan right now at the end of the forbearance. If you are able to get income again and be able to make your monthly payment again, then they're just like, okay, fine, we'll just stick it on the end of the loan. Or they may put it in as a deferred balloon that doesn't gain interest and just sits at the back end of your mortgage, and at your maturity date you have to pay those missing months in a big lump sum at the end of the loan term. In COVID, the late charges have also been waived for these missed payments, so you don't have to worry about late payments or late charges racking up, even though the payments are getting deferred. So at this point, one of the things we've been telling people is, try for forbearance in the in COVID season and see if you can get it, because it is ultimately the most affordable and usually best option for people. Non-COVID times, it's not great, but then if you can work out some sort of repayment plan, just like whenever you get behind on anything, can you make a payment and a half over a certain period of time? It's usually a very short period of time. If you can do that, then they may put you in a repayment plan. But by far the most popular option is a loan modification. And that's whenever you take the terms that were from the original note, which are the interest rate, the principal and interest amount, and then how long the loan was for. If it was a 30-year mortgage, those are the three main items that get modified in order to lower your payment. Step one typically is lowering the interest rate. Then you extend the term. Again, if you have a 30-year mortgage you've paid for 20 years, one of the options is to stretch it back out to 30 years by sort of naturally lowering the payment because you're paying over a longer period of time. And then the option is to chop off part of the principal or just take the delinquency and put it on the back end. That's what people say as a subordinate mortgage or a deferred interest balloon on the back of the mortgage. I want to talk a little bit about the HEMAP program, because that was our most popular program when during the Obama administration, during the original foreclosure crisis in 2008, 2009. HEMAP was created. Different than HEMAP. HEMAP is the Homeowners Affordable Modification Program. And what it did was it standardized for the banks sort of some goals to make modifications operate under similar principles. And they followed very strict guidelines in terms of the goal was to try and get every payment to be 31% or less of a homeowner's household gross monthly income, because they felt like it was reasonable to ask someone to pay 31% of their GMI, gross monthly income, towards their housing. So that was the goal. And the interest rate could get lowered as low as 2% and sometimes stepped up to a slightly higher rate over the following years. Extended the term out to 40 years. And if possible, forgave the part of the principal balance. And that program was eliminated in 2016. It did help a lot of people who were caught up in the subprime mortgage crisis. And it was a great standard to follow. The only remaining HEMAP is FHA has a version of HEMAP now that they'll call FHA HEMAP, but it does have some different terms, and it's the only thing that has kind of lasted from the Obama years and the Obama program. But loan modifications do tend to be pretty popular, and Fannie Mae has a flex mod that they'll consider. FHA has the waterfall. So this is something that most people, when they're putting in their financials for review by the servicer is looking, again, like Rachel said, to mitigate their own losses, but also they don't want to be homeowners. So if they can create an affordable payment for someone, then they will hopefully try to do that. and make an offer of a loan modification that comes as though it's a new loan closing, and you have to sign off and get everything notarized, and then send it back, and it gets booked in the mortgage company's database as almost a brand new loan. So that's our most popular resolution to many of these cases. If the mortgage company says, no, there's nothing we can do, we can't modify it, we can't do anything for you, sorry. A retention option that you may have is a Chapter 13 bankruptcy. And a Chapter 13 isn't like you file Chapter 13 and it just wipes out your debt and then you're good. That's a Chapter 7 can liquidate non-secured debt. A Chapter 13 basically takes what you're behind and creates a restructured repayment, a restructuring of the debt so that you can make your mortgage payment as though you had never gotten behind to the mortgage company, and then you pay a supplemental payment to the trustee according to the Chapter 13 plan that will pay off what you owe over a period of 3 to 5 years. It's a complicated process, and I'm not going to talk any more than that, but that is one of the options that you may be able to consider.
Stop it.
Okay. Kelly, are you?
I'm so sorry. My 7-year-old was bugging the cat and I didn't realize I was unmuted. I apologize.
Stop it. Okay.
I'm so sorry. I do need to launch a Sally poll box question though. So you'll have a minute and a half, attorneys, and Michelle and Rachel, please feel free to continue. And again, I'm sorry about that.
Totally fine.
These are the joys of working from home. We have all been there. I've just banished my pets and my children to outside for the moment.
I did not realize my finger had touched the button to unmute myself.
That's totally fine. I thought you had strong feelings about Chapter 13. All right. So anyway, one of the last and not recommended options typically is for homeowners who are, like I said, 62 and older. One of your retention options may be to try and qualify for a reverse mortgage. I will explain more later. It's something that can wipe off the debt, that can wipe off the existing mortgage debt if you have enough equity to cover it. But typically it wipes out your entire equity and then you're left with nothing and you don't have a monthly payment, but you still have to pay taxes and insurance, and it doesn't always work out great. There are a few, I think reverse mortgages get sold to like 10 homeowners and it's probably right for one of them. So we'll talk more about that later. And then of course, litigation is an option if you want to try and make some sort of workout through a settlement or through taking it all the way to a trial. In terms of non-retention options, one of the things that people will get in a letter, often they'll say, well, look, there's nothing we can do. We can't modify your loan. So you have we can only offer you a deed in lieu or short sale. A deed in lieu of foreclosure is to protect your credit from getting a foreclosure on it. In a judicial foreclosure state, foreclosure takes a really long time, like I said. And so getting to a point where that makes sense for our homeowners, by the time a deed in lieu looks like an option, typically foreclosure has already been filed and you're already several months behind, so your credit is already ruined. Those are most used in non-judicial foreclosure states or counties before the foreclosure action starts. If a person is underwater and they don't want to keep the house, they can choose a deed in lieu. It's designed to help foreclosure on avoid a foreclosure. It doesn't clear title. You just basically, I've had people put their keys in an envelope and mail it to the servicer and say, here you go, I'm done. You can have the house, I'm walking away. And then they move down south or whatever. That is a version of a deed in lieu. But it does have to be approved by the servicer. And if there's any title encumbrances, then usually the servicer will not approve it. A short sale. Often people think that a short sale means a short period of time. If you plan to sell your house and can get enough to pay off your mortgage, that's a market rate sale, and you can actually put your house on the market and sell it if you are in foreclosure at any point in the process. However, people think a short sale means a sale that happens quickly in a short period of time, and that's not the case. It actually means that the money that is offered in a market rate sale will not pay off the existing mortgage balance. It will be short. It's a short payoff. The mortgage servicer has to approve this and accept the short payoff. It also is difficult if there is any money owed for any liens or whatever, because it doesn't clear the title. And it often has to be within, you know, $5,000 or $10,000 of what the mortgage balance is. I haven't seen a lot of these go through, and they're a lot of work. So in Pennsylvania, in most instances, we advise letting the house go to sheriff sale if you don't really want to keep it, or if you see no way that you can afford it. Let the house go to a sheriff sale instead of the other non-retention options, and try to negotiate what we call a graceful exit and cash for keys. That's the timeline. That's whenever you present a timeline for the homeowner to agree to leave the house empty and broom clean by a certain date in exchange for a cash payout after an inspection. So those tend to be easier for people who need some time to gather some money and resources to be able to move and find a new place. And it avoids the sheriff having to come and do a big grand lockout of the property. And it saves the mortgage company some money because they don't have to go through that process either and pay for that. And so if you can work something like that out with the mortgage company or the mortgage company attorneys, that's a pretty good option for people who have to leave. Now Rachel's going to talk to us about litigation.
I will. And I will say a couple of quick things about short sale. A lot of times homeowners will say, well, I'm sure the lender will just tell us what amount they want. What's their bottom line number that they'll accept? And they won't give you that information generally. I've never been successful in obtaining that magic number. Also, it's important to that your homeowner work with a realtor who knows what they're doing with regard to short sales, because it is a different process. It takes more time. The buyer in these, while they may be getting a little bit of a deal, it just drags the process out, so it can be frustrating, and a good realtor can manage all of that and manage those expectations. But it can be complicated. It also, and I think another important reason that we sometimes say, listen, if you're not going to stay in the house, just let it go to sale. Some people believe that it'll preserve their credit score and it'll make a big difference. And we have found it just doesn't. It doesn't preserve your credit. At that point in the foreclosure, your credit's been pretty destroyed. So doing a short sale versus letting it go to sheriff's sale is negligible at that point. So those are a couple of things to consider. I have had homeowners who sell above market rate and it's not short, and they walk away with a little bit of cash, which they're entitled to, which is great, but that's generally the exception and not the rule in short sales, or at least I should say what we see here in Philadelphia. It may look different where you are throughout the state, but that's generally what we're talking about. And cash for keys and graceful exit, we see anywhere, I would say, and Michelle, correct me if I'm wrong, anywhere from $1,500 to sometimes $5,000. But that, again, the exception, not the rule. It's hard to get money, but it's nothing to sneeze at, depending on moving costs and what your homeowners need. So, but to the extent, if you're thinking maybe it's 10, 15, 20,000, something like that, it's just not. It's a relatively small amount, I would say. But can be meaningful to a homeowner who's trying to start over or move their family, that sort of thing. All right. So next we're going to talk about getting what I would generally talk about is getting information from the lender about what's happening behind the scenes. There are ways to do that. And it's called requests for information or notices of error. And it's a way to communicate with the lender in writing to say, you got this wrong, fix it, or to say, I need to understand more about the payment history, for example. And so you have the Real Estate Settlement Procedures Act, which sort of is the umbrella over all real estate transactions. And then HUD promulgated Reg X, which implements RESPA. But then the Consumer Financial Protection Bureau, a little toothless these days, but still in existence, back in 2013 said, let's look at Reg X and let's make it better, and let's do some things with it that are going to be beneficial to consumers. And so one of those things was talking about requests for information and notices of error and making it easier to get that information. So a couple of important things with these. If you're going to send something to the lender, it has to go to a very specific address. The servicer is supposed to tell you what that address is and to make it accessible. As a practical matter, check on the back of a mortgage statement or check on their website. It has to be sent to that address. It does not have to be sent via certified mail, but we recommend that you do so you know that it gets there. And they have to respond within 30 business days. In fact, they have to confirm receipt within 5 business days, but then they have to answer your request in 30 business days. And again, this is a great way to find out all sorts of information about what's happening behind the scenes when you submit what we call a loss mitigation application to a lender. You get notes about communication that the lender has had with your client. This is great for litigation purposes. So when your client's telling you, somebody on the phone told me that I was approved for this and then I never heard anything again, or they took it back, you can get those notes and you can start to parse through some of that stuff. You can find out if the application that you submitted with all of the financial information is complete. You can find out what the loss mitigation options are going to be for your particular client. If you don't have it all memorized, whether it's FHA, Fannie, Freddie, waterfall, no waterfall, all of that sort of thing, you can write to the lender and figure that out and ask them to tell you with that. You can challenge the lender if they've denied a loan modification. Maybe you did run your client through a waterfall on an FHA loan and you know that they should qualify for a loan modification and the lender has said no. You can send a notice of error to say, you got this wrong, tell me what happened here. And you can put all of that in writing. You can challenge the denials. You can ask for further explanation. It's a really great and important tool to use. I've included information that we will send out after. NCLC, I should have said this at the beginning, National Consumer Law Center. They're based out of Boston and they are the gurus in all of this. Anything and everything you can think of related to mortgages and other areas of consumer law. They have such fantastic materials in their library, which is accessible online. And we get a lot of our information. CLS uses this regularly to tap into easy read guides, easy read charts. They really boil it down for you about things to consider. And they have a great written piece on what we call RFIs and NOEs, requests for information and notices of error. And in that, it includes sample letters. The other important thing to include in your letter is identifying information of your borrower. Rachel Gallegos, my address is this, my loan number is this. The letters can come from homeowners themselves. The letters can come from advocates. But you have to have identifying information in there so they can figure out which homeowner that they are dealing with. So these are great tools to get more information as you're trying to determine what your strategy is going to be to litigate. And you're trying to figure out what your best next step is for a particular homeowner. So we really encourage, and NCLC would say this too, we've been to their conferences where they are always begging people to use these tools and to send these letters. And I know Michelle, who works with another Rachel in our office, who's doing affirmative litigation and digging deeper into these cases. I know that that your team uses these letters and sends these on a regular basis as well. So they can be a really helpful tool. If there's anything you want to add, Michelle, because I know you've had more experience, quite frankly, in sending these than I have.
I don't. I can say that for the most part, if servicers are trying to just sort of brush you off, then they'll send you a payment history and sort of say, oh, all the rest of your questions are cumbersome. But sometimes they do give you really good information and useful information within the time period. And you do sometimes have to send them over and over again before and get kind of annoying if they don't respond within the time period. And then hopefully you'll get some of the information that you need. Rachel, someone asked a question about whether or not RESPA applies to private lenders rather than just big market lenders and servicers. Do you know the answer to that?
I believe that they do, but I actually can't say that definitively. I should know that, but I'm not sure. I believe that they do. We can check on that. And if there's anyone else that can chime in the chat who wants to answer that, please do. But if not, I will circle back on that. And then I do see another question about how to submit a loss mitigation application. And I would say the answer is typical attorney fashion. It depends. I like to do it myself because I can really do it with a fine-tooth comb and make sure all the boxes are checked, make sure every box is filled in, make sure that all the documentation that the lender requires is included. And some homeowners are more than capable of doing that on their own, but a lot of homeowners, and this is something that we probably should have talked about at the beginning, but maybe goes without saying given the work that we all on this call do. is foreclosure. When a client comes in with a foreclosure notice or is fallen behind, it's a symptom of some other trauma that's happening in their life. It's a death in the family. It's a massive job loss. It's something else traumatic is happening. So the idea of a homeowner then sifting through this application and putting together all this detailed financial information is overwhelming. I think it's overwhelming in the best of circumstances and everything going on. So I like to provide that assistance. Sometimes I will refer somebody to a housing counselor if I can, but I know that they are overburdened as well. So I try to keep it in-house, and maybe I'll enlist the help of a paralegal on our team to help me get all the information together. But generally, I would say I would advise working with an advocate, whether that be a housing counselor, a lawyer, or a paralegal, to go over the loss mitigation application. Again, because it's oddly detailed, and because the lenders are so notorious for losing the information or not reviewing it in a timely fashion, the last thing you want to have is, even though they're supposed to respond within a specific time frame, you don't want to waste 45 days because your homeowner missed a bank statement, or the homeowner didn't include the amount they pay for a utility per month. Something simple like that, that maybe you, as somebody who's not going through that trauma in their personal life, can put another set of eyes to and do so, and make sure that the application is submitted correctly from the beginning.
I'm just going to jump in here and add that if you are planning to take this to some sort of litigation and represent a homeowner, it is a good idea to have someone else put through the application, whether that's a housing counselor that you can work with, or a paralegal that I have been asked before to take the stand, to be a witness, to say, I put in this application and this is the result of it, rather than having the attorney have to say, I put in the application. So that does get a little bit tricky. And also sometimes for very basic cases, housing counselors can handle it, and they have to keep track of everything that they submit in a database, whereas a homeowner can say, well, I faxed this one document, or I sent this one thing because they called and asked for it. A housing counselor can keep good track of documents that they submit and are supposed to keep notes of everything, so that and send it by email to the lenders and to the lenders' attorneys at times. So sometimes that's useful for you as an attorney if you're going to take it to the next steps, that you can call on that housing counselor and say, you know, exactly what happened if your homeowner is not a great record keeper. That's all.
The other piece I wanted to touch on for the notices of error and requests for information that's important is, a lot of times at this point, these lenders are represented by attorneys. It is not good enough just to send it to the attorney for Wells Fargo or Bank of America and then have them pass it along. You need to send it directly to the lender. So I know a lot of times ethically we think about, well, we can't be talking with the other party directly. We have to go through counsel. In this instance, you can go directly to the lender and send this notice and this request for information directly to the lender. And that's important. Don't assume that because you're sending it to opposing counsel that it's going to get there. Quite frankly, it won't. And it's not their obligation, and they know that. So you can copy them on it. It's not a bad idea to do that to build your record, but send it directly to the lender servicer. Okay, so sometimes you got to litigate these cases, right? And quite frankly, I don't do that. I don't do that a whole lot. I'll be real honest with you. But it is an option because we're a judicial foreclosure state. It runs through the Court of Common Pleas in your county like any other civil case would. You are entitled to discovery. You are entitled to motion practice. You are entitled to all of that sort of thing. So litigation can be part of your strategy. In Philadelphia, we have the benefit, as Michelle said, of the conciliation. So we could park a case there before we have to decide if we're going to file an answer or do anything. You may not have that option in the county where you are at. I know that conciliation programs are different and they run differently, and maybe they provide you some downtime, so to speak, to do loss mitigation, and maybe they don't. So maybe this litigation strategy has to be employed a little bit differently, but it can be part of your arsenal of tools. A lot of times it's difficult because when you're talking about a mortgage foreclosure, there's no dispute that your homeowner hasn't made the payments, right? So it's hard to come in with a good defense and figure out what you're going to say. We're all kind of on the same page that our homeowner didn't make the payments. There's exceptions to that, right? Sometimes a homeowner comes in and says, I don't know what this is. I've been making all of my payments. Here's a stack of receipts. what are we going to do about this? That's different. That's typically not what we're seeing in our day-to-day practice. So you have to come up with other defenses and that sort of thing. So here's some general information about parties and pleadings and who must be named and what they have to include in the complaint. If you've seen a foreclosure complaint, they are not long, right? It's maybe 1 or 2 pages. Those lender attorneys are thin on the details in those complaints. But they do have to include certain things, and you'll see those pleading requirements in the rules, and you'll see it on this slide. Defendants need to be named even if they're not on the mortgage, but maybe they're on the deed. So sometimes you'll see people come in and say, well, I'm just on the deed, I'm not on the mortgage, but you're still going to be named as a defendant. You can't sue dead people, we know that, but they have to start the action over, and then they have to name a personal representative of the estate. That can go into a whole other, open up a whole other can of worms, and we'll talk at the very end about some tangled title stuff to consider and to be aware of as you're doing these cases. But the estate can be named as a defendant, and the personal representative should be named as well to step in. Your options are different if you are not the borrower and you are defending a foreclosure and you are trying to resolve it. But you do have options. You do have some options there. Counterclaims and trials. So foreclosures can be tricky because counterclaims have to relate back to the origination, but by the time that we're seeing these cases, maybe we're a decade past origination, maybe we're 2 decades past origination. Sometimes you get people who default early on, but really your counterclaims are going to be very, very limited. The case law is not helpful in that regard, unfortunately, but you still have defenses. While you may not have counterclaims, you still have defenses, and that's where you can start talking about servicing and loss mitigation, and you didn't review me correctly, things like that. Bench or jury trial. You know your audience. If you're going to go down that route, know your county, know your judge, and understand that these can be very, very fact-heavy cases, which sometimes lend itself to a jury. But if we're talking about financials and things like that, perhaps you have a great judge who's better suited for it. CLS has been seeing challenges to whether or not you're entitled to a jury trial. We're seeing that in Philadelphia a lot, but we always maintain that we are and have briefing along those lines to support that. I would say rarely, rarely, rarely are these cases going all the way to trial. It just doesn't happen a ton. So that's really not where you're headed. We're interested in home retention. So defenses to foreclosure. This can be, it's a whole other CLE. If you have further questions about defenses, we can send you a great outline that our colleague Rachel LaBush has created that really goes into a lot of depth about the defenses that are available. But the big ones are the notice defenses. And we talked a little bit about this with our Act 6 and our Act 91. By statute, they have to include specific and itemized information. So failing to include that can be a great defense. Including attorney's fees that shouldn't be there can be part of that. Maybe they get the amount wrong. Do the math. They get the amount wrong in these cases. They include interest that shouldn't be there, things like that. So check those notices. They seem very formulaic, and it's easy to just kind of glance past them, but read them with a fine-tooth comb. Ask your homeowner if this number makes sense. When did you actually fall behind? This is telling me you fell behind in June of 2019. And the homeowner says, no, that's not when I fell behind. I made that payment. Whatever it is, you have some really good defenses there. Proceeding while the HEMAP application is pending. Did the lender do that? We talked about in the beginning that if the homeowner meets with the housing counselor within 33 days, it puts a halt on things. Did the homeowner or did the lender violate that? That's important. That can be a defense. Servicing defenses. So for FHA loans, there's a whole HUD handbook, which we link to in the slide, and you'll see when we send out materials that tell you what the lender has to do. The lender has to work with the homeowner and do all sorts of very, very specific things to consider them for a home retention option. If you have an FHA loan and your lender has not followed those guidelines, you can assert them as defenses. We talk about Reg X as well. Reg X, I would say the HUD handbook, by example, works in conjunction with Regulation X. So the HUD handbook says you have to do these 100 different things when running homeowners through the waterfall, and the very specific types of loss mitigation options that may be available. And Reg X says this is the timelines in which you have to do it. And here's how you have to respond to a homeowner who submits a request for information. So those things can be read together and can both be asserted as defenses. And another important piece is you can't dual track. So what that means is if I submit a loss mitigation application, you can't sell my house. There's some more detail around that, but that's generally a very important one. If I get that application in now, you can't sell my house in December if you haven't given me a response. And so that's often something we use in motion practice if we're trying to postpone a sale. Hey, I submitted a loan modification application and they never responded, so they can't sell my house. The dual tracking is really, really important. It's gotten better over the years, but it still happens. Lender servicers are often not as in tune to the details and the regulations with these loans as we'd like them to be, to say it more diplomatically. Again, we can talk for hours about defenses, but I tried to highlight some of the bigger ones that we see or that people ask us about. Origination defenses, and that's when you hear about predatory lending and that sort of thing, and unconscionability at the time of origination. We don't see a ton of predatory lending stuff happening that's coming through CLS these days. I think it was more prevalent in the early 2000s. But it's still a defense you should consider. And when you're looking at what's happening and you're listening to your homeowner tell you their story about how they fell behind, interactions they've had with the lenders, or maybe it's a recent loan and they're telling you about what happened when they were sitting down to closing and things that they were told at that table, pay attention, because that's when you'll see some problems. Capacity. Sometimes we do see capacity issues, somebody coming in, they've fallen behind on a mortgage, and as we're unfolding the facts, we realize that did this person really have the ability to sign all these documents and obligate themselves under this contract? So you can raise a capacity defense. There's always standing rules, paying attention to who's bringing the action. Follow the assignments. Sometimes by way of personal example, we purchased a house, it went through a very small lender in the neighborhood, and then it was immediately assigned to Wells Fargo. And then sometimes you'll look at a homeowner's paperwork and you'll realize that it's been assigned a number of different times. So pay attention to those assignments and make sure the proper party is the plaintiff in your action. Unclean hands, I know that comes up in a lot of different civil actions, but it's relevant here, and it's always something we assert as a defense here. It's very rare that I would say that a lender has done everything correctly, right? So this is always going to be relevant because 9 times out of 10, they've screwed up the servicing at some point. They've screwed up the loan modification application. They've messed up in their denial. They've messed up in what's available to a homeowner. So that's going to come in. Equity, there are equity defenses that you can raise, and it's a useful defense, as I say here, such as a pending HEMAP application, or other sympathetic circumstances. This is where you can really plead your homeowner's case and the borrower's case here in a court pleading, and you should take advantage and you should do that. There are lots of other defenses specific to maybe a VA loan or a USDA loan, those types of things. But that we won't go too much into detail here because, again, we could just talk about it for hours. But those are some big ones to consider and to be aware of. But again, I can't stress enough looking at those pre-foreclosure notices as a great way to do it. And looking at the lender's behavior after you submit the loan modification application. Are they responsive? In the proper timelines? Is it a very obvious case, or of course your homeowner can afford this and they're denying you for some unknown reason? If you're looking at it and you're saying this seems odd, that right there, listen to that. That's a good, if this doesn't pass the smell test, it sounds silly, but ask the question, do the request for information, send a notice of error, get more information. It feels sometimes like a black box when you're dealing with lenders and you don't understand what's happening behind the scenes, but you can get some of that information. You can get a lot of that information. to better understand what the options are for your homeowner and whether or not you should be filing an answer to that complaint to press them. And maybe the goal of filing an answer to the complaint is not to undo the whole transaction and to undo the mortgage and get your homeowner a free house. But what it does is it forces a further level of review, and it forces the lender to go back and to take another look. And that's important because circumstances can change, another review can be done. Or maybe what it does is it buys your homeowner time and they find another job if they've lost income, or income changes and you resubmit another loan modification later on, which you can do. So defenses are about substantive defenses, but also about time. And that's a really important thing. So Michelle and I were laughing because we were like, the reverse mortgage slide just kind of pops up in here and is apropos of nothing, but that's sort of what a reverse mortgage is. It's its own entity. It's its own thing. It has to be talked about separately. So I'm going to kick it back to Michelle to talk about reverse mortgages. And I saw Beth Shea in the chat here, and I know, Beth, you've had a lot of experience with these as well. So please chime in with anything you might want to add as well. But Michelle?
Yep, thanks, Rachel. So this is a 101 level class. So I'm going to give you a basic overview because you may have heard of reverse mortgages, and we felt like it was important to talk about them because, like I said, it doesn't seem like a payment that you don't, or a loan that you don't have to make payments on can go into foreclosure. I'm going to tell you what they are and how to deal with a potential foreclosure and why that might come up. A reverse mortgage is a loan for homeowners who are 62 and older and who should have considerable home equity. They can borrow against the value of their home and receive funds from that equity as a lump sum or as a fixed monthly payment or line of credit. Unlike a forward mortgage, which is the type that we've been talking about, the type you use to buy a home, a reverse mortgage doesn't require the homeowner to make any loan payments. One of the things that we see is that a homeowner, whenever I said that we don't necessarily recommend these, is because there's a pretty complicated formula that the homeowner's age, the equity, or the value of the house, and any existing liens goes into this formula, and whether or not they have enough money or credit to be able to qualify for this type of loan. Often what we see is that someone who just turned 62, basically the younger you are, the less money you get out of the equity of your house. If you're in your 80s or 90s, then they'll give you a bunch of equity because it's based on life expectancy. And if they don't expect you to live much longer, then they can give you all that money and then recoup it back. But what we see often is that they get sold to people who are 61 and a half, and it wipes completely all of their equity out of a house just to pay off the existing loan balance, and then they're left with nothing, no equity, and then a growing loan that continues to grow over the next 30 years. A common misunderstanding about these mortgages is that they encumber the home so the homeowners cannot leave their homes just through a will to family members or heirs debt-free when they pass away. The heir has to pay off the mortgage at 95% of the home value at the time of the person's death, or the mortgage balance, 95% of the mortgage balance, whichever is lower. The homeowner has to pay taxes and insurance annually, even though they have this loan. And sometimes taxes get really high and become unaffordable, and so they lose their home because they can't afford their taxes. And getting on a payment plan with the city could work for them to pay property taxes, or with the county or township or whatever entity you're paying. But the reverse mortgage companies and servicers often don't recognize those payment plans with the local entities, and will sometimes advance the funds and pay off the mortgage, the property tax balance, and then charge the homeowner a huge lump sum for it. Sometimes homeowners are confused about who's responsible for the payments. Mortgage brokers for reverse mortgages sometimes are very slick and will say, you don't have to worry about anything from here. And that means, or they'll cover the first year of taxes and insurance at the time of closing. And for someone who's used to having their taxes and insurance escrowed, they don't realize that they also are responsible to pay their own taxes and keep up on their homeowner's insurance. And it sometimes is very confusing, and it can take a couple of years even before the mortgage servicers will let people know, you haven't paid your taxes, we've force placed insurance on you, now you owe us a bunch of money for taxes and insurance that you've ignored over the years. Okay, so the loans become due and payable. This is the foreclosure and delinquency default bit. What the person is required to do if they have a reverse mortgage is that they have to keep the house in good maintenance. They have to live in the house as their primary residence for as long as they're alive, and they have to keep up the taxes and homeowners insurance. If they don't do any of those things, then the loan can go into default and a foreclosure action can start. If a reverse mortgage servicer advances the homeowner's insurance costs or the delinquent taxes or even current taxes before the year is even up, then the homeowner has to pay the servicer back. There are a lot of details about how a homeowner can enter a repayment agreement about this, but often they're like, we have in Philadelphia, we have some fantastic property tax programs that are that make it really affordable for a senior on a fixed income to be able to stay in their home. But the reverse mortgage servicers do not have great programs like that. Sometimes it's hit or miss if you can qualify for a repayment program, depending on how big the balance is and what your income is. So often the servicers will demand that you pay back the advance in a lump sum, or you can arrange some sort of limited repayment agreement. There is something called an at-risk extension, which means that they will extend the time that they will move forward on a foreclosure action. But that requires a homeowner to be 80 years old or older. They have to have some sort of critical circumstance, like a terminal illness or a long-term physical disability or a unique opportunity need, like someone living at the house who is receiving care. And then you have to ask HUD for this extension, and it has to be renewed annually and approved annually by HUD. So every year, this like older than 80-year-old sick person has to still tell HUD that they are still poor and sick and old, and get an extension on whether or not they have to pay their delinquency or their amount that the servicer has advanced. They don't make any payments in that case, but again, it's kind of a program that's a little bit of a pain in the neck because they have to continuously get doctor's letters and show their income and their budget every year and prove that they still have this hardship. Defenses to a reverse mortgage foreclosure are really limited unless there are new provisions for spouses who were taken off of the deed at the time of the origination because they were old and you have to or because they were younger. And sometimes if you have two homeowners and one is 75 and one is 85, the agent would sometimes say, it'll be fine, we'll just remove the 75-year-old because you'll get more money for the older adult. And then the older adult spouse dies, and then the 75-year-old the deed is no longer in that person's name, the mortgage is not in their name, and then the servicer would say, well, you have to go. There are new provisions that we can fight a surviving spouse situation, and that's a defense to keep the person in the house. But in terms of payments, if they cannot afford to pay back the delinquency, or if a person passes away and the family members can't afford to pay off the mortgage back to the mortgage servicer at 95% of fair market value or 95% of loan balance, then you just kind of let it run its course and try and buy as much time as you can. The family can, or the estate can sell the property, or even the homeowner can sell the property, but it does have to exceed the balance that the loan has grown to, because unlike a forward mortgage, which shrinks, a reverse mortgage grows. So that in a nutshell is a reverse mortgage, and what you might face if you have someone who comes to you saying, hey, I've heard about these reverse mortgages, they seem like great ideas, or my reverse mortgage servicer has put me in foreclosure and I don't understand why. So.
All right. So all of this is well and good, except COVID, right? So there's a whole other overlay that the coronavirus has caused. It's probably the understatement of the year. And it has greatly affected the foreclosure universe. And I'm sure we've all seen all the headlines since March about foreclosure moratoriums, foreclosure forbearances, no sheriff sales, on and on and on. And there's a lot of information out there. And so we tried to sort of summarize it as best we could. I have to give a shout out to my supervisor, Mike Froelich, for creating this handy dandy chart for us to try to keep track of what's happening about whether or not new foreclosures can be filed and what happens to existing cases. And so you can see the federally backed mortgages, no new filings before the end of the year. Same thing for Fannie, Freddie, and VA loans. And there's links to where that information is about those moratoriums, I guess we'll call them, through the end of the year. But there are plenty of cases that were filed before March, right? So what's happening with those? So FHAs are suspended. They're not moving forward on those loans. And same thing with Fannie Freddie, also suspended. So a good portion of the foreclosure universe is just on hold until the end of the year. Not federally backed mortgages. And this is where we get Pennsylvania specific with what Governor Wolf said at the beginning of September. Which boils down to notices at this point where we are in October, pre-foreclosure notices can be sent. We don't have a good sense at CLS of how many of those have been sent or what's really happening. Again, because homeowners typically come to us later in the process. So I would ask you all, are you seeing them? Are notices being sent? That sort of thing. We just don't know, but technically they can be sent. And then for non-federally backed mortgages, it depends on the lender and it depends on local court rules. In Philadelphia, we are not seeing a rush of non-federally backed mortgages with new filings and moving forward to foreclosure. Anecdotally, what we know from our opposing counsel that we have relationships with is everything is on hold. There's nothing moving forward. And in fact, to that end, I'm sure a lot of you have seen or heard that Phelan Hallinan, which is a huge lender firm in Pennsylvania, especially in Philadelphia, and they have a New Jersey office too, they shut their doors about a week ago, just completely stopped. And so they no longer exist. So if you have cases, if you are already practicing in this area and you have cases with Phelan, I know they had offices everywhere and they had local counsel across the state. Pay attention because you're going to have a new attorney entering appearances on those. It was very shocking, actually. So that's what's happening with foreclosures in Pennsylvania. But then there's the CARES Act. The CARES Act funneled a ton of money in to help homeowners and renters too, but we're talking about homeowners, of course. NCLC, we go back to the NCLC magic. They created a wonderful chart, which I keep bookmarked, that tells you what to expect with foreclosure alternatives. And this is where we talk a lot about forbearances. Homeowners are entitled to forbearances if they were affected by coronavirus, and that's really important. But the more important piece, which we have yet to see totally play out, is, okay, once those forbearances are done, what happens? And so in a perfect world, a homeowner can pay what they missed and they're back on track, but that's really not what we're seeing and what's going to happen with our low-income borrowers. And so what's going to happen is we're going to apply for loan modifications. And we're going to say, let's take all those forbearance payments and all those payments that were missed during the 6 or 12-month period. Let's recast the loan, modify it, and make it affordable payment going forward. But the good news is there are forbearances out there available. Homeowners should be encouraged to contact their lender immediately to request that forbearance and to put the loan on hold, so to speak, so that fees and costs aren't being accrued during this time. So again, I refer you to the NCLC chart that talks about the differences in the FHA forbearances, the Fannie Freddie forbearances, all of that. Forbearance, 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 really helpful for people who have lost jobs and lost income and are under great financial duress right now. They should not also have to worry about what's happening with the mortgage. And there is a bit of a pause here that we can take as an industry to say, okay, nothing's going to move forward. The bad news is, and what we're all a little bit worried about, is what's going to happen when the forbearances stop, when the moratoriums end. So 2021 is going to be interesting and difficult to watch play out, because I think we're going to see a tsunami of foreclosures that are going to be coming down the pike, much in the same way that 2008 was. So the other line of assistance we have is PMAP, the Pandemic Mortgage Assistance Program. And I've bolded and underlying the deadline, which was extended to November 4th. This is being administered through PHFA, which is our state housing finance agency. You can apply online or via mail. And generally, here's who's eligible. Homeowners, as I write here, who as a result of COVID-19 became unemployed after March 1st, 2020, or had their annual household income reduced by 30% or more due to reduced work hours and wages. Now, there's nothing in the PMAP guidelines that say that specifically that you can't have fallen behind before March. Anecdotally, if you call and you say, hey, my homeowner applied, they will tell you, well, your homeowner was already behind before March. There's a movement to try to challenge that. And I encourage other people to tune in here about that if they've had experience with that. But that's what I'm being told over the phone is you can't have been behind before March, but we want to push back on that and see if we can make some headway there. Because as we all know, maybe you were behind before March, but then maybe your income was further reduced after Corona hit. That is a very, very common story that we are hearing. So we encourage those homeowners to also apply. We need people to apply. The stats about the amount of money that they have spent under PMAP for homeowners, not renters, is just abysmal. It's so low. It's just not been the success that we have hoped it is, but there is more opportunity to apply for assistance. And so we encourage people to apply for that assistance to cover the mortgage payments since March directly to the lender. It's a really great thing for those who can apply. My experience has been, again, at CLS, we just don't see homeowners that early on. A homeowner who's fallen behind as of March pre-COVID, even if we didn't have this overlay, we wouldn't see them until maybe they're 6 or 12 months behind in some cases. So it's hard to figure out how to get in touch with homeowners who may be behind, who don't know about this assistance, but please share it with all of your networks. I know that if you're in the housing world, you see all the information about PMAP coming out on all sorts of listservs and whatnot, but we really need to share with homeowners across the state that this assistance is available. And people should take advantage of it. The PHFA website has all the information, and there's a great FAQ. It's actually pretty easy to navigate. And so there's a lot more detail about who's eligible, owner occupied, that sort of thing. I can't believe it is 11:29. And I am not looking at the chat right now. So if there are questions in there, I'm not seeing them. But Michelle, I'm relying on you.
Nope, we're fine.
Okay.
I think Beth had some clarifying information.
Thank you, Beth, as always.
I just need to launch the second CLE poll box for attorneys. You'll have a minute and a half to respond, and please continue.
Well, that is it. We won't keep you past your 90-minute deadline here. Again, thank you all so much. Our contact information is on these slides. We will send out information. CLS is here statewide to help you all answer questions we can't litigate in outside counties, but we can certainly have a conversation with you about what's going on in your particular case. And we love those conversations. And we like to talk with other people who are doing this work. We know there's not a lot of attorneys out there, but we're here as a resource. And you should not hesitate to ask us. So if you have a bankruptcy question, we have bankruptcy experts. If you want to bring affirmative litigation, we have experts that do that. We kind of run the gamut here. We're very fortunate. And we want to share that knowledge, and we want to help people succeed in these cases, because as we all know, homeownership means a lot to these families and to these communities, and it's about stability and living a life of dignity. And so thank you all so much for joining us today. Thank you so much, Michelle, for presenting with me. And thank you, Plan. thank you, Plan, for this wonderful conference and this virtual setting. It's a crazy time, but it's great to be able to share information with our colleagues across the state in a format like this. So hopefully we'll see you all in person in 2021, maybe. Register to vote. That's my last plea. And thank you all so much.
Thank you, Rachel and Michelle, for taking the time to share this information with us. And thank you, everyone, for attending. And we will see you next time. Everybody have a good day.